Welcome and thank you for joining part one of Seyfarth's micro-webinar series, Half an Hour for Healthcare, Helpful Hints for Healthcare Companies in California Wage and Hour Issues. This session will cover classification. All participants are in listen-only mode. You are encouraged to submit questions throughout the program using the Q&A feature located on the right side of your WebEx window. We will do our best to get to everyone's questions. However, if your question is not answered, our presenters will follow up with you directly in the days ahead. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and is required for CLE credit. Copies of the webinar recording and materials will be distributed to attendees in the days following the presentation. At this time, I'd like to turn the program over to Bailey Byfoss.
Thanks, Christian. Hi, everybody. I am Bailey. I'm an associate in Seyfarth's San Francisco office. I'm here today with Andrew, who's a partner in one of our LA offices. As Christian just mentioned, if you all have questions today, feel free to use the Q&A button. Time permitting, we will try to answer them at the end. If we don't get to your question, rest assured one of us would be more than happy to follow up directly with you. You can also ping us. Our email addresses are going to be here in the slides. You can call your Seyfarth attorney of choice. Whatever you want to do to get a hold of somebody to get your questions answered, or we can follow up with you. We're grateful for your attendance here today. Thanks for coming. So why are we doing a healthcare series? Christian, would you do next slide, please? There's plenty to talk about here in California. We've got wage and hour updates, we've got EEO updates, we've got what the California Supreme Court is up to, we've got litigation trends. So why are we doing a focus on the healthcare industry in particular? Well, the answer is because healthcare is different. We have different rules that apply, and we have healthcare companies that are affected differently by generally applicable rules. It is an industry that is unique in California. How so? Subject to different staffing considerations. It's not a business that traditionally is probably open from 9 to 5. We have a lot of healthcare providers that operate 24 hours a day, 7 days a week. It makes staffing different. It makes staffing more difficult in some respects. We have ratios that we need to adhere to with respect to staffing. And who are the people that we're staffing? We've got tons of different classifications, right? We've got nurses, we've got physical therapists, we've got pharmacists, we've got techs, we've got HR people, we've got admins, we've got all of these different classifications of employees. And a lot of those folks are highly sophisticated, educated employees, folks that are registered, who are licensed, who are certified. We pay people in ways that are unique. We have a lot of reliance on differentials and special premiums, which oftentimes gives us a lot of different pay codes. It becomes an issue when we're talking about regular rate issues. And next slide, please. And sometimes we see commercial timekeeping companies that are challenged by the complexities of the hospital setting. We have workflows that change quickly and change often. We have folks being sent home early. We have folks needing to be on call so that they can come in on a moment's notice. We have folks floating between units. We have folks working on alternative schedules. And that's before we even get to all of these special rules that apply just to the healthcare industry. Exempt classification is one that we're going to talk about today, where we have special rules that apply just to us. We have special overtime rules. We have special meal period waiver rules. We have CBAs. We have joint employer issues. We could probably do a whole presentation just on home health pay structures. So there's a lot here, and that's why we've put together this series. And it is a series. Next slide, please. So today we're going to talk about 3 topics. We're going to talk about employee classification, and within that, we're going to talk about exempt status, about joint employment, and about union represented employees. We are going to have parts 2 and 3 to this series. Same deal, half an hour, easy to plug into your morning, and we're going to cover a lot of the other topics that I just mentioned. We're going to talk about compensable time. We're going to talk about work days and work weeks and meal periods and regular rate and all of that jazz. So keep an eye out for emails on those 2 parts of the series. And with that, let's dive in. Next slide, please. Awesome. So you're probably familiar with traditional exempt employee tests. In case you're not, we've got two major categories here, right? We've got exempt and non-exempt, with the caveat that it is actually way more complicated than this. The really high-level summation is you have to pay overtime to your non-exempt employees, and you do not have to pay overtime to your exempt employees. Again, more complicated than that, but just from super high level. So what makes somebody exempt? It's traditionally a two-part test. So your first part is the salary basis requirement. Everybody who's going to be classified as exempt has to be paid a salary that has to be at least 2 times the minimum wage for full-time employment. Base level requirement for somebody to be properly classified as an exempt employee. That one's typically relatively straightforward. The one that is typically a little more complicated is the duties test. You have to be performing duties that fall generally into one of these specially identified buckets in order to be properly classified as exempt. The 3 big ones that we're used to seeing are administrative, executive, professional. Administrative, we're talking about department heads. Think about your HR director, not your administrative assistant generally. Department heads, that kind of administrative. Executive are generally your managers. Have to supervise at least a couple of people in order to qualify under that one. Professional actually has 2 parts. You have folks that are licensed or certified by the state and engaged in the practice of a handful of specially identified professions. One of them is law, one of them is medicine. So we're talking about physicians, we're talking about dentists. And then there's this learned professional exemption, which applies to folks who are engaged in the practice of work that requires some sort of advanced knowledge in a field or science. It's customarily associated with some specialized course of instruction or study, something like that. And there's a qualitative and a quantitative element to the exemption test. The qualitative is they have to be doing the things. They have to be doing the things that fall into one of these buckets, and they have to be using some level of independent judgment and discretion when they're doing it. The quantitative piece is they have to be doing that stuff at least 50 or more than 50% of the time. California is not a primary duties state. It is a quantitative analysis. For folks to be classified properly as exempt, they have to be doing these activities at least 51% of the time. So let's look at a question on the next slide. Thank you. Seattle Grace Hospital would like to classify mid-level providers and physical therapy staff as exempt. So which of the following employees is not going to qualify for the professional exemption? We just talked about the professional exemption, right? It's got these 2 parts, the part that applies to licensed employees and the part that applies to employees who are engaged or required to undergo some specialized course of study. So with that in mind, which of these positions are not going to qualify for the professional exemption? Give everybody a chance to sort of look at the list and get their answer in mind. So the answer is that E, physical therapist aides, and G, clinical nurse specialists are a no, which is surprising, right? So let's talk about exempt status in the healthcare industry, which is on the next slide. So under the wage order, pharmacists who are employed to engage in the practice of pharmacy and nurses who are engaged in the practice of nursing are not exempt under the professional exemption. This is a unique California thing where nurses and pharmacists are non-exempt, right? Because traditionally they would fall within one of the categories that we just talked about. They're licensed, they have to go through this significant course of specialized study. Like they should be exempt. They should fall within one of the buckets that we just talked about. But by statute, they don't. They're exempted. Now, just because they can't be exempt under the professional exemption, it is not necessarily the case that they still can't qualify under another exemption. So what about pharmacy managers? Technically, that's a pharmacist, but if we're talking about a pharmacy manager who is engaged in genuine management, who's engaged in supervision, in scheduling, in documentation, in paperwork, that person could qualify under the executive exemption, and they wouldn't be precluded from doing that just because they're exempted from the professional exemption and by the statute, by these requirements. Same deal with nursing managers. Everybody here probably knows that there is always plenty of work for nurse managers. There's so much management with respect to the scheduling and the paperwork and the regulatory compliance. There are, of course, always going to be patient emergencies that are all hands on deck. There's always going to be some level of patient care. But I will say we don't see a lot of nursing managers spending less than 50% of their time on management activities. There's just so much to be done in that particular job classification. Still, it is a thing to be aware of, is the 50% rule when we're talking about somebody who's like a nurse manager. One other question on this point that we often get is whether we can pay nursing managers extra when they're picking up extra shifts. There's a Saturday shift. We want to know if the nursing manager can pick it up and pay them extra for that shift. Short answer is yeah, you can. So long as we're talking about paying those folks on top of their guaranteed weekly salary, it's not going to be an issue for you to pay the nursing manager extra for the extra shift. And then I took this out of order, but this advanced practice nurse exemption is something to be aware of. Thinking about our last slide, we said nurse midwives, nurse anesthetists, nurse practitioners are exempt, but clinical nurse specialists are not. Everyone sort of recognizes that there are these 4 categories of specialized nurses. Only 3 of them are built into this specialized exemption, where midwives, anesthetists, and nurse practitioners, those folks are okay to be exempt, even though, and exempt specifically under the professional exemption, even though they are engaged in the practice of nursing. The same is not true for clinical nurse specialists. Do I know why that distinction was made? I do not. Do I think that it makes a lot of sense? I do not. But it is what the statute says, is that these 3 categories of nurses okay to be treated as exempt under the professional exemption. But outside of that, if you have a nurse who is engaged in the practice of nursing, they have to be classified as non-exempt pursuant to the terms of the regulations that healthcare industries are subject to. Now, we talked about how there are a ton of different employee classifications in the healthcare industry. Not all of them are nurses, not all of them are pharmacists. So I'm going to hand it over to Andrew to talk a little bit about the exemption as it applies to another major category of healthcare employee, which is physicians.
So as Bailey mentioned, you've got both the salary basis test and the duties test when you're talking about exemptions. And so a question arises frequently with regard to physicians of, can a physician be exempt without qualifying for the salary basis part of the test? And the answer is yes. So in California, you can pay a physician on an hourly basis and maintain the exemption. It's Labor Code Section 515.6. Couple of caveats, though. The hourly rate that you have to pay is at least $97.99. Currently, it adjusts each year, so effectively $98 an hour at the moment. And the physician, that has to be paid for each hour that the physician is working. So that's not just seeing patients, that's doing charting, that's training, time between patients. So it's important that if you're going to be paying a physician on an hourly basis, you're fully accounting for all of time worked, and the doctor needs to be accurately tracking all of the time if you want to avail yourself of this exemption. It's also important to note, because we get this question frequently, but under the federal law, aren't physicians just exempt if they're licensed? And the answer to that question is yes, but again, California is different, and so you can't rely on the FLSA in California with regard to the exemption. And so it is true outside of California, you don't need to worry about that, but inside of California, with regard to doctors, you do. It's also important to keep in mind that this particular safe harbor does not apply to interns or residents or doctors who are covered under a CBA. Another thing that we see come up fairly frequently is day rates. And so can you pay a doctor a day rate and maintain the exemption? Answer, yes, you can. As long as in the aggregate, the day rate at least equals the total amount that would be required under a salary basis on an annual basis, which currently is $64,480 in California. Next slide, Christian. Okay, so let's move off of exemptions for a moment and let's talk about joint employment. So why are we talking about joint employment? Well, joint employment in the healthcare industry is particularly important, and we see quite a bit of litigation about this in the healthcare industry because of the very prevalent use of staffing agencies, where we're talking nurse registries, traveler agencies, or just vendors for various different staffing, janitorial services, security, etc. We also see this come up in the context of integrated healthcare systems, where you have an employee who may work for one part of the system and another part simultaneously. So there are, frankly, a number of joint employment tests that float around. Under the federal law, there's one set of tests, but again, we're in California, and California is different. So the baseline in California comes out of a Supreme Court case called Martinez versus Combs. And the Supreme Court set forth 3 different ways that you could be a joint employer. So each of these leads to the result that you're a joint employer. One is if you exercise control over wages, hours, or working conditions, or if you suffer and permit the worker to perform services for you, or you engage the employee under the traditional common law test of employment, which focuses on right to control. Now, critically in California, it's important to understand that it's not just right to control whether you've actually exercised it, it's the nascent right to control. And so many times we hear, yes, but I never actually supervise that person. Well, if you reserve the right to supervise that person, that's sufficient to be a joint employer, whether or not you actually exercise that right. Next slide, Christian. In addition to that, if that's not bad enough, the Department of Labor, the Federal Department of Labor, has been pushing a theory that they call horizontal joint employment, which is contrasted with vertical joint employment, which are the issues that we just talked about, focusing on right to control. So in horizontal joint employment, what that's focusing on is where you have an employee who works for 2 different employers, but those employers are so closely related that they should be considered the same employer for the purposes of payment of overtime. And so what we see this a lot is where you have an integrated healthcare system. And so the Department of Labor issued an opinion letter finding joint employment by related hospitals. And the fact pattern there is interesting and frightening. So what the DOL focused on is that the hospital shared a common president and board of directors, that one entity provided administrative support to the other, and that they had overlapping personnel policies. And this was even though they had separate HR departments handbooks, payroll. Nonetheless, the Department of Labor said that can give rise to joint employment. So to make matters even worse in California, California has yet another way that you can be on the hook. And this applies to if you use staffing agencies, labor contractors to supply some of your workforce. And it's Labor Code section 2810.3. And what this section does is make the client employer per se liable for the payment or non-payment, I should say, of wages with the labor contractor, with a couple of caveats. First is there's a particular notice provision that has to be availed. So if a plaintiff in a lawsuit is going to try to go this route, they have to provide a specific notice under the code. Additionally, it doesn't apply if you have less than 25 workers, usually not an issue for large healthcare clients, or if the labor contractor is providing 5 or fewer people. So it's a one-off, that's not going to apply. But otherwise, you could be jointly and severally liable if your labor contractor, your staffing agency, fails to pay its employees' wages. So that's a pitfall in California that you need to be careful about. Next slide. So what does it mean? So you're a joint employer. Well, it can mean a lot of things. And let me pause here to say that we're just today talking about wage and hour issues. Being a joint employer has ramifications in a whole series of areas. So there can be EEO compliance issues, sex harassment. There can be union issues under the NLRA in terms of collective bargaining. Because of time limitations, we're just going to focus on wage and hour issues today. So in the wage and hour context, if you're a joint employer, it means you might be jointly liable for the payment of all wages, including overtime, meal and rest break compliance and premiums, whether or not people are properly working on alternative work schedules, if there are wage statement violations, potentially final pay, Labor Code Section 203, and all of the derivative claims, notice keeping, et cetera. Now, the reason I said may is because there is some law that says that, for example, if you have a staffing agency that is responsible for the payment of these people, and you simply make a lump sum payment to the staffing agency, that there are arguments in litigation that you should not be fully liable for the screw-ups of the staffing agency. They're very fact specific. We're not going to have time to get into all of those right now, but I do want to flag that. Next slide. Okay, so what can you do to potentially avoid joint employment liability? Well, there are a number of steps. One, in your contracts, you can make it very clear you're not the employer, in that your contractor, your vendor, is responsible for all aspects of the employment relationship, setting of the wages, the payment of benefits, et cetera, et cetera. Even better if they are responsible for the hiring, the supervision, the discipline, in that you're not getting involved in that. Now, that's difficult in a lot of situations, and the reality is that that's probably not going to work very well in many situations, especially when we're talking about the supervision of employees. Another thing that you can consider, and this is really in regard to class action liability, you can consider having your vendor have its employees sign an arbitration agreement that has a class action waiver that expressly names you as a third-party beneficiary. That at least gives you some protection against potential class action with you being named as a defendant, and so you would then be limited to just dealing with one-off situations. Next slide. So, as I said, there are often it's difficult to give up full control or supervision. And so you may end up simply finding yourself in a place where you say, you know what, given how broad joint employment is in California, we're going to be a joint employer. So what do you do to minimize the risk when you're dealing with vendors and staffing agencies? One, make sure you have strong indemnification language in your contract. Two, avoid the mom and pop staffing agencies, because if you're using them, a couple of things. One, they're probably not very sophisticated and they're liable to screw up, more liable to screw up. Two, your indemnification clause isn't going to be worth very much if you've got a mom and pop agency. Three, before you hire them, or retain them, I should say, make sure you investigate how they pay people. Are they compliant? You might want to consider having an audit provision in your contracts that allows you to have the staffing agency tell you how they're paying people and provide proof that they're paying people correctly. Similarly, you may want to provide certain forms to your agency, for example, meal break waivers or other policies, so that it's very clear you know that they're doing it properly because you've drafted them, you've given it to them. Also, make sure that if you know you're going to be in a joint employment situation, provide some sort of a contact internally so that you can be aware if people aren't being paid properly, and you can raise that issue immediately with the vendor and make sure that they're taking care of it up front. Over to Bailey.
Thanks, Andrew. Can we go to the next slide, please? All right, CLE code. CLE code, just so everybody has it, is SS as in Seyfarth shop 9487. Again, that's SS 9487. Next slide, please. All right, we've got another question here, which is Cook County General Hospital uses travel nurses from a staffing agency. The hospital tracks the nurses' hours and its employees supervise their work, but the staffing agency pays the nurses' wages. Are the hospital and the staffing agency joint employers? I'm not going to spend a ton of time here since we've got 2 minutes left, but it will not surprise you. We're lawyers. Of course, the answer is it depends. What does it depend on? All of the things that Andrew just talked about. Is there a right of control reserved as being kind of one of the big primary considerations here? What are the terms of the agreement between the staffing agency and the healthcare provider? Things like that. Next slide, please. And this is our last piece. Even setting aside worker status classifications, another classification issue with hospital employees is between represented and non-represented employees. So separate and apart from whether an employee is classified as exempt or whether the employee is classified as an employee of two joint employers, this is whether an employee is represented by a union or not. And it's in here because it has implications. It matters for purposes of our wage and hour compliance. The short version is this. There are a variety of exemptions within the labor code and the wage orders for union represented employees. The most significant one is, I think, the overtime exemption in Section 514 of the labor code. Section 514 exempts employees who are covered by a valid CBA from the state's overtime laws. It is critically important, if you are relying on this exemption, that you make sure that your CBA satisfies all of the requirements of Section 514. The CBA has to provide for the wages, for the hours of work, for the working conditions of employees. It has to provide a premium wage rate for all overtime hours worked. It has to provide a regular hourly rate of pay of not less than 130% of the state minimum wage, more than 30% higher than the state minimum wage. If your CBA does not satisfy these requirements, then it cannot qualify for the exemption under Labor Code Section 514. There's a common misunderstanding that there are meal and rest period exemptions. There aren't, sorry, but there are others. There's a day of rest exemption. There's paid sick leave exemption. The state of California has taken the position that unions that are bargaining on behalf of their employees have the ability to exempt those employees from certain provisions of the labor code, but you have to make sure that your CBA says what it has to say in order to qualify for those exemptions. And with that, I know we're a minute over. I want to be respectful of everybody's time. We thank you again so much for your attendance today. Our email addresses, our phone numbers are up on the screen right now. If you have any questions, obviously we didn't have time to get to any in the chat. Sorry about that. But if you have any, feel free to reach out to one of us or another Seyfarth attorney. And thank you again. Hope everybody has a great rest of their day.